Thank you. So for the record, Delegate Michelle Guyton, District 42B, Baltimore County, and I am here to respectfully request a thoughtful and favorable report on House Bill 1046. I do have sponsor amendments that I have already sent to you in the committee, and this bill is very simple. It purely requires schools to have a plan for parents to be notified when a mandated reporter reports abuse, either physical or sexual, of your child to CPS. Again, I'm going to continue. Now, this requirement applies only if the suspected abuser, the person who is being reported, is in the school, is a school employee or at a school-sponsored event. This is not going to apply if the school reports suspected abuse by a parent for obvious reasons, because of concerns with the child's safety. So currently, only a few school systems have really sound policies regarding notification to parents or guardians under these circumstances. And I do want to point out that two of the very best on which I fashioned the amendments that you have in front of you are Howard County, a really robust program, and Baltimore County. So the amendments really the final amendments came from Baltimore County, because I think they do an excellent job putting a lot of this in actual regulation. So most systems, however, have no policy regarding when and whether a parent needs to be notified if their child has experienced sexual or suspected physical assault. And none of them, including Baltimore and Howard County, have actual requirements that the parent be told if they believe the child needs medical care. Okay. So, simply, there is an ongoing case right now that you will hear a little bit about. I cannot speak to it because you're going to hear from the attorney, and I don't want to do anything to jeopardize that case. You will hear about that case, and that is one of the many cases that have come before us that makes it obvious that we need to put something like this in place. If your child falls down at school and they skin their knee and have to go to the nurse and get a Band-Aid, as a parent, you are alerted. You get either a written note or a call from that nurse. If your child is the subject of a CPS report and the same nurse believes that the child may have been sexually assaulted that day, they do not have to tell you. And to me and to the parents that have been in this situation, that makes no sense. So this is a parental rights bill, but it's also a child safety bill. I want to let you know that DHS and MSDE are in favor of this bill, and I've talked with both of those departments at length. They believe this is a necessary change that they would like to see brought forward by this committee. The amendments that I put before you, again, mostly from Baltimore County, mostly satisfy the concerns of some of the informational letters that you have from MSCA and PSAM. They wanted more specificity about who would be required to make that report and specific languages about making sure that the integrity of an investigation was protected. And I believe that we have covered these in the amendments that you have before you. I'm going to turn it over to my two virtual witnesses to give you more information, but I sincerely hope that we can have a long and really vital conversation about what is an important hole in our education policy right now. Thank you so much.
Thank you, Delegate, for bringing this important bill. We do have two oral witnesses, and I see Ms. Scott. You can proceed.
Good afternoon, Chair Wilkins and members of the committee. For the record, my name is Lori Scott, and I'm here in support of House Bill 1046. Thank you, Delegate Guyton, for bringing this forward. As the mother of a child with significant cognitive and physical disabilities, and as a school nurse practicing in Maryland, the concern of not notifying parents if a situation occurs where a mandatory reporter feels the need to contact CPS because he or she has seen something by someone who has put a child at risk, and the school system not calling the parent or guardian is really difficult to understand. If you're a parent, I'm sure you will agree. Any student who is neurotypical or one who has disabilities can be affected by this issue. Neurotypical students may feel too scared or violated or have been threatened and may not tell a trusted adult what is going on if they are being harmed or pursued by a teacher or someone else in the school building. Parents should be notified as soon as CPS is notified or as soon as possible thereafter to ensure a student is behaviorally, emotionally, and physically safe. By notifying the parents or guardian, they can make the decision to determine if medical attention is needed and the child needs an exam by a physician. The assurance of notification will minimize this process, is the delay in this process. Additionally, if a nonverbal student comes home with significant trauma or behaviors or emotional challenges or refusal to eat or sleep, parents at least have been put on notice that something potentially could have happened, and they can begin the process to restore the child's emotional and physical and mental health well-being. After reviewing several districts with Delegate Guyton, we found that this gap was ever present, and hopefully by passing this bill, we can actively secure timely medical, clinical, and emotional support for students at a faster pace than what is currently happening. Days and days could pass before parents are made aware of something that happened to a student in the school building. Student safety and well-being should always be our first priority, shouldn't it? Please give this bill a favorable report so we can close this gap. Thank you for your time today.
Thank you for your testimony. Let's go to the next virtual witness. Ms. Van Cleef, you can proceed.
Thank you. Good afternoon, Chair Wilkins and members of the committee. My name is Ashley Van Cleef, and I'm here in strong support of House Bill 1046. I'm an attorney who represents parents of children with disabilities and also a former special education teacher and a former school system attorney. I'm also a parent and a grandparent. In all of these roles, my work has centered on supporting children and working with families. As a teacher and a parent myself, if I knew a child may have been abused or harmed at school, I would have wanted that child's parents contacted immediately. Parents need that information to seek medical care, to pursue therapy, and sometimes just to simply understand the sudden changes in their child's behavior and to be able to provide that support that they need to help them overcome that. Without that information, parents are left confused, frightened, and powerless. Unfortunately, this is not a hypothetical situation. During this 25-26 school year, 3 separate families from various counties across the state have come to me after their child was suspected of being abused by a school staff member. Each of those families told me the same thing. They were not notified when CPS was contacted, and that was scary. They didn't know what had happened to their child. They didn't know whether their child was safe to return to school. And as a result, they felt that they could no longer send their child to school. The McAleer case in Frederick County has certainly been one that's been widely spread within the news, but it illustrates this gap. A school aide was charged with sexual abuse of minors and sexual offenses against children under the age of 14, involving our most vulnerable students in a special education program. Yet the parents were initially told that only something had happened at school without the details, and they were only told before this was to be released to the news. Another family told me their child really didn't want to go to school, threw tantrums, thought that they just didn't want to follow the rules. And if they had known something had been happening sooner, they could have understood what was going on and certainly had more suspicions whenever they started seeing bruises on their child. This happens because many school system policies do not require notifying parents, and we are asking you to support this bill because parents have the absolute right to know and the need to know. Thank you.
I see a question from Delegate Miller.
Thank you, Madam Chair. And thank you, Delegate, for bringing this very important bill to close some of the loopholes that exist. Obviously, Frederick County has been severely impacted. And it was surprising to me. It seems that people in education think that they're mandated reporters, but only on the parents, not about what happens in the schools themselves. Has that been your experience, and is that part of why you're bringing the bill to keep parents in the loop? And then the other part of it that kind of goes along with it is, I know you talked about some of the letters of information. I was kind of surprised by the unfavorable from the nurse practitioner and the pediatricians because, as Ms. Van Cleef said, if you notice those changes in your child or any kind of bruising or anything, you would want to involve medical professionals sooner, as a parent, unless, of course, the parent's under suspicion and all of that piece of it. So can you speak a little bit more to that, or maybe Ms. Van Cleef could talk a little bit more about that aspect of it?
Sure. Well, I can speak to that piece. We were not my office wasn't contacted by those unfavorables. We saw it the same time that you saw it. Although we did yesterday afternoon reach out to all the unfavorables, because it was my understanding from reading their letters that they actually didn't recognize that we were only talking about people who were within the school system and abused the child. A lot of their testimony dealt with making sure the child was safe and not alerting the parents to the fact the parents might be under suspicion. And that bill does not do that. That bill does nothing in that realm at all. And so we reached out to have that conversation with them, particularly the pediatricians, which I was very, very surprised at. And we're still trying to have those conversations, but we did let them know through email and also phone messages that I think they're not understanding what this bill is doing. And as to your first point, mandatory reporters are mandatory reporters for any abuse that they see in the school, and something that they may suspect coming from home, but also if there's a volunteer in the school that's doing something inappropriate, if there's an aide, if there's a vendor, if there's a janitor, if there's a school bus driver, any abuse that occurs on the school that they may be aware of at all. And so I don't know that confusion is there. I think it's when I've done trainings, I think that's been very clear, but so this bill isn't really directed at making sure that they make those reports. What this bill is directed toward is the fact that parents should never, ever, ever find out that their child may have been sexually abused when they're watching the nightly news.
Agree. And I think some of the confusion is actually they follow their internal processes rather than activating the external processes that are meant to design to protect kids in mandatory reporting situations. So, Ms. Van Cleef, did you have anything that you wanted to add? I know you work very closely with these families and parents.
I do, and truly this is where we just found a loophole. School staff are doing what they were supposed to do and doing the report to CPS, but then they didn't know that they were also needing to contact the parents because the policies and procedures in some school districts don't lay that out, and they didn't know if they should or shouldn't. And this is where we want to close that gap and just say, yes, you absolutely should and you can, so that school staff are aware that that is something that should be done.
Thank you. And thank you both for all you're doing for our families.
Thank you, Delegate. I was along the same lines, taking a look at the unfavorable testimony, because I think there's such an important issue that we have to make sure we get right. And I imagine that there could be instances in which there might need to be some flexibility based on the facts of the case in terms of who is notified. And that's where it seemed the medical community and social workers were landing with their unfavorable. And so I know that you have amendments. We'll take a look at them. But I did want you to comment on if your amendments will address the issue of perhaps there's a reason why a parent should not be notified, such as what the social workers were discussing, which is cases where they are going through the process and the parent may be involved somehow or may put the child at risk, things like that, if there's any comment that you can make.
Sure. Thank you for letting me address that. Again, not having had the conversations directly with them, and I'm still continuing that process. I do believe that the amendments that we put forward, and mostly in response to MSEA and PSAM and MABE, does address that to some extent. Now, if the parents are involved in any way, they should not be a part of the notification. And I think that the bill is very clear on that. If the bill needs more clarification on that piece of it, that the parent can't be also abusing the child, I mean, I'm not sure what the wording would be there, then they obviously would not be notified. The bill does not say that the parents should be notified if the parents are involved in any way. So that's where I thought they may have misunderstood the intent of the bill. And since Delegate Polakovich-Carr has always taught me to say the intent of this bill is that school-sponsored events and school activities and actual days in school are protected children are protected from people in the school or working at those events or volunteering at those events. And if they are assaulted or assumed to be assaulted, that will be reported to CPS, and that the parents will then have a report as well. In our amendment language, again, taken mostly from Baltimore County, a little bit from Howard County, we did add a couple of things about the fact that the information should never be disclosed in a way that's going to jeopardize a case. And I think that may have been part of what they were getting at. If a parent knew that, Bob, the special ed teacher, had done something to their child, it was suspected, then they maybe would have gone after that person. I think I was reading in between the lines a little bit on that. That information would not be given to the parent. Very specific information about who, specifically what, anything that would jeopardize a legal case, because ultimately we want the child to be safe. We want the parent to be able to comfort the child and take care of the child, but we also really want that perpetrator to be charged and out of the school system. So that is all equally important. And I think that we did balance that in the amendment under 2, Roman letter 2, number 2. And then we also dealt with some of the MSEA concerns with who was going to be reporting and when they were going to be reporting in letter C there, number C, which means a school principal in consultation with law enforcement, consultation with CPS, would help make these decisions to make sure that the case wasn't compromised, and also that the appropriate person would be having these conversations. So it's not spelled out in this bill now with these amendments that it has to be the principal or admin. It can be law enforcement that does it. They just need to do it. And I did add in this bill that this is just from a parental point of view and from what a lot of people have experienced. The bill does state that they need to do it before the start of the next school day. And that is for obvious reasons, so that the child doesn't come to school having been abused, having gone through some traumatic event, have to be re-traumatized, and the parents not know about it until later in the day. So that's just a portion that we thought was very important for parent protection, but mostly for student protection.
Thank you so much. I appreciate that, Delegate.
Thank you.
Delegate Eversole with a question.
Thank you, Madam Chair, and thank you for bringing this bill. There's lots of times we think we need a report. We talked about bullying and all sorts of stuff, and you are attaching one here. Having been a teacher and having made reports like this, it's a painful thing to realize you have to do. We always believed that once we gave it to social services that their procedures would take care of this as necessary. So can you go through what this is adding, or what Child Protective Services doesn't do that this does?
Sure. They don't have a mandated time period to tell the parents. That's what this bill does. And I can let Ashley speak to the legal aspects of that and the process if you'd like.
Mm-hmm.
Sure, absolutely. So as we think about some of these cases that have actually occurred this year, it was weeks until the parents found out that there had been a report. And that's the problem here. So CPS may have been notified and CPS was doing what they were doing, but they had no obligation to tell the parent. In some instances, it didn't come until right before the news release was going to go out that the parents were notified. And then the parents have completely lost trust within the school system. And you and I both, as former educators, that trust is everything, right? So if our parents don't trust us, we've got serious issues that then boil into more and more issues. But as we develop that relationship between parent and teacher, being open and honest and transparent is incredibly important. And I think that that's the biggest piece as we think about CPS has no obligation to notify, and we fall apart there in this important notice to the parents.
And that's a critical thing, if I may follow up, Madam Chair. So you said CPS has no obligation to notify. I would like to believe that they're more expert in determining that sort of thing than, say, a school principal or a counselor, where they have other areas of expertise. What about the idea of actually requiring CPS when they find it appropriate to do this notification? Because I think they might be better arbiters of whether or not it was appropriate. It's not just a parent. It could be the whole household situation that they determine, or any one of a number of things that not just the parent being the abuser here, but someone else. Could we turn it around and ask CPS to have a timeline on them?
Yeah, thank you for that. And I think you just said it might not just be the parent being the abuser. This doesn't apply to parent or household abuse at all. This bill does not. This is only abuse that occurs in school, on school property.
Oh, I'm sorry.
Or school, yeah. So that does not, yeah, no, it does not apply because for obvious reasons, you're exactly correct. You would not want to I don't think it's wise for CPS or school to let a parent know they were under investigation. So that is not a part of this bill.
Okay.
I agree with you on that 100%.
That clarifies
Yeah.
a lot. Sorry,
Yeah.
I missed that little piece.
Yeah, it's a big piece. And DHS has
words,
come
but a
out.
big piece, yes.
Yeah, DHS has come out in favor of this. They agree, and particularly with the amendment that says it's not just the school administration, but it's also CPS and it's also law enforcement that will make these decisions. I think that addresses your question, and DHS agrees that this is something that we need to handle, and
Yeah,
they are favorable in the bill.
Going forward, it might be interesting to put CPS under some pressure in cases of abuse outside the classroom as well, to.
We can do that next year. I'm all for
Give
it,
it some
sir.
thought. Thank you.
Seeing no other questions, thank you again, Delegate. That ends the bill hearing for House Bill
Thank you. Thank you all.
1046. No problem.